So at this juncture, I'd like to ask Nelson to come up here if he can to speak on some of the findings that he's got, and we are actually very excited about this, so here's Nelson.
I'm Nelson and from Penticton, and I guess I've been fighting my friend called Canada Revenue Agency for probably 10 years plus, in and out of court. I would say with them 20, 25 times, something to that effect. Well, that's good. So about 3 weeks ago, I guess it was, I attended with, heard about a deal in Penticton where they're having a council meeting. So what I did is I decided to go down and listen, and Kevin over here put on quite a presentation to the city guys for about 5 minutes. And in there I met a guy named Curtis Bennett, who was out of Kelowna. After having coffee with him for a couple hours, looking over his credentials, etc., I decided, and getting a little bit of education, that maybe I should take on the city of Penticton legally after looking at my analog meter that was on the house. So the first thing I did the next morning, at about 6 o'clock, is I done up a letter directed to the city of Penticton, who's the hydro provider in our area, and I told them pretty well, and I'll just have to put my glasses on. I just said to them, after reviewing information from the City of Penticton Council meeting on January 9, 2012, in regards to the new current meters being installed by the city, I see many problems could arise. This letter is to advise you that the current meter, that being a Sanyo Company Limited CJ3S701154, showing the City of Penticton number 6704, not to be removed from this current meter base until written permission is received from me. Please respond to me within the next 10 days in writing at the below listed address. I took this down, and you can see here by 9:30 the City of Penticton didn't want to accept it, so I told them that I was prepared to have one of their free coffees and wait for the mayor to show up at 10 o'clock. So after they reviewed it with 3 different supervisors, they stamped it. I said, no, I don't want the stamp. I also want some initials, which by law you need. So they nicely initialed it, and I said, thank you very much. Have a nice day. And about 2 hours later, my phone rings. It's the City of Penticton. They advised me that they will not be removing my analog meter. I thought, beautiful. I think I'm on something. So I went further. But anyways, at the same time I was down there, and I don't know how many people know about a good law, and you can get all kinds of information, and there's a British Columbia information law. And you can file that, and everybody should, I think. And with that law that's in here, freedom of information, the provider of hydro, whoever you get it from, has got to legally supply you all the information, if you word it right, that they have in their files in regards to the wireless meters. I just said in this one, complete documentation currently held by the above named public body in regards to the attached Senron and Itron meters and any other meters that this public body intends to or has information in these files. This must include all notes, reports, etc. in regards to this request by all City of Penticton personnel, including the mayor and council to date. 2 attachments I attach, and in there is 2 pictures that Kevin took of 2 meters in Penticton. About 3 hours after, of course, they didn't want to accept that again. So I said, well, I'll go have a coffee with the mayor then, I'll wait for him. So they accepted it, there's their stamp, and they initialed it. So I said, thank you very much and have a good day. About 2 hours later, another Penticton salaried employee, I'm sure, phoned me and said, what's this about? I said, read the law. So we had a brief discussion. They said that these 2 meters here in the back were not wireless devices. When we finished our discussion, he fully agreed with us. That yes, they are wireless devices, and I said, I don't want them. He said, you won't have them on your house. So I said, thank you very much. There is the letter I received from the city of Penticton in regards to the freedom of information, which lawfully they have to supply you within 5 days. And it says, please accept this letter as an acknowledgement of your request dated the 11th, information pertaining to the electric meters. Under the Act, the City of Penticton has 30 business days to respond to the Freedom of Information request. The city received your request on January 11th. We will respond by February 21st or earlier if possible. If you have any questions, please contact me. Okay, legally, they have to send you that within 5 days of your request. One step further, after 30 days, on about the 20th day, if they can't get the information together for you, they'll ask you for a 30-day extension. Legally, you don't have to give it to them. I strongly suggest you do. So in 60 days, you should have a copy of everything that they have in the file in regards to wireless meters. And you can do that provincially, municipal, federally. It's all there, just a different act. And it's great. I've done probably 25 or something in my lifetime, and I can tell you people, the stuff that you get, you don't think the government ever had. It'll open your eyes. Good reading material. One other thing I did is, for the last many years, I have a private trespass sign on my doors, etc., and one by my meter now. And really, it just goes on. No trespassing applies to any debt collectors, any third-party collectors, provincial and federal government agents, any and all authorized, unsolicited, and uninvited individual. Anyone wishing to enter upon this property must supply their oath of allegiance and oath of office by certificate of Her Majesty the Queen II, as noted within the Criminal Code of Canada, Section 337. All trespassers will be subject to fines in the amount of $3,000 to $3 million for each infraction at the owner's absolute discretion, and forfeits of any or all vehicles brought onto this property by trespassing hereon. You agree to the above terms. Private property, no trespassing. I took it one step further. 2 CRA agents decided that they'd like to come on my property. I said, fine, thank you very much. Took their information. 2 days later, I went down to small debts court. I filed a small debts court action for $10,000 against each of them. And they didn't really want their money, but anyways, in their personal capacity name, not under CRA. The lawyer got involved, and I said, no, it's under their name, they got to come to court. I was lucky I had a good judge that I know a little bit about. Mr. Sinclair, we came to court date. He gave me a judgment against them both for each of them for $10,000. I said, I don't want their $10,000. I want you to give me an order for $1,000 each. They have 48 hours to pay for, issue it to Salvation Army. He gladly went along with it. CRA agents, I know for a fact, went down and paid $1,000 each to Salvation Army. I won it. I can tell you, they do not fool around with my property anymore. Because, and the city already knows about that, I know that. It was in the paper down there one day. Okay, so then, my letter that I put, I'm saying to the city, in regards to my meter, was pretty shabby. But I done it because I thought I had to do it right away, and I wish I didn't do it, because then maybe they would have changed my meter and I would have been able to take them to court. Because I have a problem here. I think that we're going down, possibly going down one wrong road. If we look at what we filed here, or some people's filed against the Utility Commission, most people will remember the Utility Commission of British Columbia were told BC Hydro, I think it's 3 years ago, that they couldn't increase the rates. But BC Hydro went ahead and increased the rates anyways. So does the Utility Commission of British Columbia have any teeth? No. So even if we're going to be successful, and I hope we are, going down that route, I don't think we're going to be able to do anything to stop the meters. So I believe that what we need is a Supreme Court injunction. And that can be done in the matter of probably 2 weeks. And there's different doors you've got to go through. I have a friend that's very knowledgeable in preparing legal documents. We'll do it free of charge. You know. Anyways, he just sent me this yesterday, and it's being shared with you people here tonight. Kevin knows about it, Brian knows about it, Warner knows about it wherever he's sitting. Okay? That's all. We're going to discuss this in regards to an injunction. Tomorrow, I'll have a conference call with and Sharon Noble, is it?
Yeah.
Okay, I'm new in this, so. Okay, and really what it is, to get an injunction, I'll just read you. The case law, one of them is Jardine Lord Thompson versus Fogel and Company, 2007, British Columbia Supreme Court 271. To meet the test, okay? Paragraph 21. The test for an injunction relief is, 1, whether there's a fair question to be tried. Is there a fair question to be tried here? I believe so. Okay? Number 2, whether there is demonstrated irreparable harm against us. Is there going to be irreparable harm? Yeah, definitely. Right? Okay? Number 3, whether the balance of convenience favors granting an injunction. Yes, it does. R.J. MacDonald versus Canada Attorney General. It goes on the whole one. And then section 385, in weighing the balance of convenience, a court must weigh that harm will befall the applicant in an injunction if an injunction is denied, but the applicant is ultimately successful in the action against the harm that will befall the respondents if an injunction is granted, and they will ultimately be successful. So if there's any harm, a lot of words there, if there's any harm possible against us from when the injunction is till the court case ends, if that's where we're going to go with it, an injunction can be granted. And the injunction, of course, I believe, and we got to talk all about this, would be strictly to stop putting on these meters. And I think with Curtis Bennett and what's happened in California, Maine, and all that, the pile is going to be that high, full of it. That's my personal opinion. So and there's other cases here, but I'm not going to go into it. But that's case law, and when you got case law in a court, that's what the judges or justices make their decision on.
It's precedence.
That's precedent. You got that right. Okay, so that's what we got. But it's only 2 days old. You're the first group to hear about it, besides 4 people last night. Okay, so what I've suggested to people, and I just shared it with Brian tonight, everybody should send this to their hydro supplier. Just a letter, registered mail, make sure that you've got the right power supplier. Attention electrical department, here it's Penticton, account number 123456778.
Nelson. May I suggest that people do that in groups, not just separately?
No.
No?
Hear me out on it.
No.
Okay? Everybody's got to do this specifically for a reason. Okay?
Yeah. I just thought it was going to give
No.
Okay.
No.
But you know more.
You're all individuals.
Yeah, okay.
You've got to do it because you all get your own meter. Okay? I have reason to believe that you or an associated company contractor acting on your behalf are about to change the electrical meter to a wireless type meter at the below listed address. This is, in all capital letters, legal notice. That's what you need. Legal notice to you that you and your associates must not proceed with this exchange without the express written consent of the registered household owner. The current sealed meter located at this address is the same as I said, and that's why you got to do it individually. You're saying don't change that analog meter such and such and such and such and such.
Yeah, but what I mean is that all those, let's call them letters, could be sent in one envelope. And
Oh, one
my-
envelope, yeah.
What my reason for doing that would be so that BC Hydro and whoever else sees that people are not doing this by themselves, but that we're getting together, and that's what they don't like to see.
Okay, what I would suggest in that case, because you
Yeah.
want the receipt that they got it. Okay, somebody, and I don't know, it was today, in the court case, I think it was, said that they sent a bunch of freedom of information stuff in, right, Kevin? That woman? And she says, I never heard back from them. And I said, have you got proof that you sent it in to them? And she said, well, no. I said, well, what I do with mine, as I did here, is I took it down and got it stamped with initial.
Yeah.
I got proof they got it.
Yeah,
So if you're going to do it that way,
Yeah.
then take it down there, take a coffee with you, and make sure they stamp everyone and initial it.
I would actually go with 2 or 3 witnesses.
Whatever, okay?
Even that.
Yeah.
Okay.
So what you want to do is you want to go out to your meter, get the data off that meter. In my case, it was a Sanyo and the serial number and Penticton number 6704. That was on that meter. Okay, so that tells them they can't change that specific meter without written authorization from the householder. And I believe it is in good, satisfactory working condition, that meter. I have reason to believe that your replacement wireless meters do not meet the Electrical Standards Act, CSA, and that residents residing in this residence could be seriously harmed from the operation of these exchange meters. You and your associates must not trespass, all capital letters, on this noted, all capital letters, private property without the express written consent from the registered household owner, except to collect the monthly data from the above listed meter required for consumption billing as agreed in our contract. Please respond to me in writing within the next 10 days at the date of this date, the letter of this date of this letter, and advise all parties associated with this in regards to the electrical energy consumption at this address. So you're doing 2 important things in law. You're telling them this is legal notice, you can't not do what you think you want to do, and that goes back to the 1400s, when the Spaniards first came into southern United States to actually invade in North America. The first thing they did, and it's in the law books if you want to go find it, they read legal notice that they were coming on board to take North America for Spain. And you go do that homework yourself. So it's doing that. It's giving them legal notice, and that's one strong thing in law. You cannot do it, bang. Then the other thing you're doing is you're double banging them because you're telling them you cannot trespass on this private property. Even if you don't have one of these signs up, this should suffice. So that's pretty well. So what I'm going to do tomorrow, after our meeting here with Brian and them tonight, I'm going to make a phone call. It's already been tentatively set up to talk to Una and Sharon Noble and discuss the injunction moving forward next week. Go ahead.
Can the city put in like their own little bylaw that they can put those on? Like,
They can do their own bylaw, but the problem is legal notice. They can't come on your private property. I suggest to everybody, it's on the internet, etc. Read page 1, 2, and 3, and maybe 4 of the Trespass Act of British Columbia.
It supersedes everything.
That's right.
Within that, I think I know what you may be getting at in effect to them to say, hey, we're this city, you can't do this here. They've basically set up the Clean Energy Act where it's provincial or federal. Therefore, I think that they're trying to say we can override your city. That's why when those councils vote for a moratorium, they've been legally able to say too bad. And so even if your council does vote for a moratorium, which is still a good thing, they still, as they have been in those other cities, despite democracy, have been walking into town and blanketing them with these meters. Therefore, what Nelson is talking about, that's why it's important for you and perhaps your neighbors, because if your neighbor gets one, you're still being exposed. So you want to allow the maximum amount of people you can to understand this.
Go ahead.
I think they do have legal right though to come on your property to read the meters.
That's what I tell them.
Yeah,
They
but
can come
that's-
on there and read the meter.
Yeah,
It's
In
a
my
very
letter.
different situation.
Yeah.
We're not
I
saying
say
it's-
that.
Yeah.
Okay.
You and yours,
Yeah, we heard.
without written consent of the registered household owner, except to collect the monthly data from the above listed meter required for the consumption billing as agreed in our contract. Right?
So basically, I think what you're saying is I or you or whoever does this says, I'm happy with the contract that we agreed to. But now you're throwing this whole other thing into the mix that I don't agree with. I'm happy to use the power, you record the data, I pay the bill, everything's fine, nothing's wrong with that. Now you start talking about switching from an analog meter, health effects, two-way radio frequency device, privacy, democracy, all these things, but more specifically some of the things he was talking about, just pick a few and put it in there and say, hey, I have a problem with this now.
Well, can't they, sorry to interrupt, but can't they just say, okay, well, we're not agreeing to the contract anymore, and then just pull your power out?
No, they can't, especially in the winter months. There's necessity law that takes precedent over everything. And my friend that's in the legal side of it, Dave, he did make a comment here, something to the effect, maybe you don't have it here. He said that there's a good possibility that the harm that comes to individuals with the frequencies, etc., we could sue all these hydros, etc., on that. But really, you got to look at where you want to be. And in my position, all I want to do is I want to take the easy way out and love my retirement, and that is don't put the meter on. And if that's good enough, hey, I wish that I didn't jump as fast as I did against the city of Penticton, and they would have, and I would have got more education. But once I gave them the letter and they accepted it so gracefully, it's too late for me to go after the city of Penticton, because I would do it. I guarantee you, because I have nothing really to do quite often. So, you know, no, I'm not a lawyer. I call them legal liars for a reason.
They're gonna sell you souls.